And then we are going to be starting on the longest module in the course, which is the contracts module. And as I said earlier this evening, contracts are the lifeblood of business. This is what makes things go. And in our daily lives, day to day, we deal with contracts, and it's pretty important. I learned a lot about contracts in my very first business when I, as I mentioned, was managing folk singers and rock bands. Is that we needed to have a contract with our venues to make sure that they paid the artists fairly. If we were going to provide a dressing room or things like that, had to be in the contract if we wanted that to happen. Also in terms of whether they were required to do 1 or 2 sets, what time they were supposed to perform, whether they got travel allowance if they were going to another city, a lot of important pieces. And so I learned a lot about contract law well before I attended law school, and made law school a little bit more relevant for me because I'd had a lot of business experience before I went there, but still is a lot to learn. And sometimes you'd be surprised. I'm dealing with some very sophisticated business people who created some very successful software, and they entered into a contract without legal assistance and are now between, excuse me, between a rock and a hard place because they've entered into a very difficult contract because of the current COVID-19 situation. They do not feel that it makes sense for them to perform the contract, but the other side is playing hardball. And because the contract has been, excuse me again, because the contract has been signed and executed by business people, it's a very difficult thing to undo when it is not very favorable to the people that have come to see me. So again, a very important lesson is to understand the importance of contracts, and it's very good to have legal review before you sign the contract and not after you get in trouble and go to an attorney and say, hey, I need you to bail me out. So not just in chapter 13, but in this module, this is a good outline for both chapter 13 and the contracts module, is we're going to look at the elements of creating a contract, the sources of the law of contracts, how they're enforced, what are the performance expectations, different legal remedies for breach of contract. And that was a question that, of course, came up earlier with regard to torts. And we're going to revisit legal remedies or damages under contracts. And then also equitable remedies. And again, equitable remedies are actions or orders of the court that are independent of money. So we have, what is a contract? Let's get down to the real basics here. It's undertaking a commitment concerning future conduct, the providing a remedy if the commitment is not performed. The form of the contract is not as critical, although business people, we want you to get it in writing. That's a very critical element to this thing is let's get this in writing. If it's worth doing, it's worth getting the contract in writing. So the agreement is a manifestation of the parties' mutual assent. It's a bargain for consideration. There are 2 or more parties involved. And there must be a legal purpose consistent with law and public policy. So folks, I try and point out to you slides that you should keep track of for your outlines for your course and in terms of preparing for your quizzes, the midterm and the final. This is a very important slide in terms of giving you the key elements necessary to create a contract. And so in terms of the law of contracts, you have what we call the common law that's made by judges. It's written down and it's not based on statutes. Now, in the United States, every state except one is a party to the Uniform Commercial Code, the UCC. And I mentioned this earlier in the course already, and we'll be talking about the UCC in several different areas of the course. And that provides a standard system. Also, there are statutes in various states that provide for different aspects of contract law. So there are statutes other than the Uniform Commercial Code as well. So part of this is that you weren't forced into having a contract. The parties are entering an agreement that is the product of their own free will. And the example that I use is a very famous saying from the movie The Godfather. And Marlon Brando, the actor playing the Godfather, says to one of his lieutenants, "Make him an offer he can't refuse." That's a contract of adhesion. Is that, in other words, if you didn't do what they wanted you to do, you might end up floating in the river or something like that, but it would be a bad end, or something bad might happen to your business and so forth. So those contracts in a legal sense would not be binding, though going to court against the Godfather is not likely what would have happened, unfortunately. So part of this is procedural and substantive unconscionability, is the unfairness with how the contract is formed. A number of consumer contracts are being challenged on unconscionability grounds, that there's so much unequal power by these huge corporations that when they force you to sign a contract, that it may be that the contract's simply not fair from the get-go. And this is an excellent example. The telecom companies, various theories, the mandatory arbitration clause, but the court held the clauses are unconscionable under Oregon law, and the service contracts were contracts of adhesion. And I think you may see more of this in the courts today, where the government has allowed so many massive mergers where many of us do not have a choice of cable television, and of with T-Mobile and Sprint merging, there's only a few major cell phone companies. And so certain pieces of pressure that are placed on you, forcing you to go to arbitration instead of being able to sue and so forth, that there's just kind of a cumulative unfairness that seems to be rolling along. One of the things is that we want your contracts to be in writing, and we want them to be bilateral, clearly a business decision between one party and another party. The book, for whatever purpose, wants you to know what a unilateral contract is, and this is a promise for performance. So a young man comes to your door and says, "Hey, Mr. Jones, I'll cut your grass for $25. You don't make a deal. You just point to the lawn. The young man interprets that as go ahead and cut the grass. He cuts the grass. He comes back and says, "Please, may I have my $25? Well, it's a contract that was performed by performance. You can see the many possibilities for a problem that could occur. That's why we want bilateral, and we want them to be express and in writing. So you can have an express contract, whether oral or in writing. But again, if you bring an oral contract to an attorney, the attorney is going to laugh you out of her office. It's let's not do that. We're good business people, and whether it's a personal matter or a business matter, we want to make sure that we have a solid written express contract that spells out the terms. Implied in fact contracts are created by the way things are being done. And they're somewhat similar to the unilateral contract on the prior slide, in that people say, "Hey, I'm going to charge you so much to do this." Then they go and do it. But one of the more interesting areas that you may encounter here is, let's think about, I know we have a number of ladies on our call tonight, and you go into a dress shop and you see a dress that you're looking for, but it's about twice as much as you can afford to spend. but you find that the dress on the mannequin has a stain on it, and you're pretty sure you can get that stain out. And the dress fits you. So you say to the sales lady, hey, I'd like to buy that dress. It's for sale for $200, but it's got a stain on it. Will you sell it to me for $100? The sales lady says, sure. She sells it to you for $100. Now, it turns out that she did not have the permission of her manager to discount the dress to $100. However, from your perspective, she was in charge of the store. There was nobody else there. Nobody else at the store stopped her from selling you the dress for $100. So most likely it was a fair deal, and it's an enforceable contract because the owner of the business set up a scenario where it was implied that this person had control of the shop and had a right to do this. So it's a pretty interesting deal. You also have quasi-contracts that are based on protecting a business. And one of the examples that I think we used the other night, which can come back around, is if you have someone that stays at a hotel and it's not clear that the terms of the room rate and everything were there, but you stayed at the hotel, you used the room service, you did things like that. So the hotel says, well, you've got a bill for $10,000 for this big stay, and you choke and you say, well, wait a minute, that wasn't what I thought our deal was. So the court may enforce a lesser amount and say, well, the room's worth $40 a night, it's not worth $400 a night, and the food's worth $20, it's not worth $40. So the court may create what they structure as an equitable situation. And that's known right at the bottom of this slide as quantum merit. So you may not, if you're the plaintiff, you may not get everything that you wanted, but you may get something that's relative to the value of the services that you provided if somebody had to go out and buy them on the open market. And so if someone is preparing to enter into a contract and then the other side backs out and says, no, we're not going to do the deal, if the first party has changed its position in reliance on the contract going through, then you may have a situation where the court will order restitution, say, look, you spent $20,000 getting ready for this contract that ended up not happening. We're going to go ahead and order the other side to pay you that $20,000. And if it's based on materials, the other side can have the materials that you stocked in, but they still are required to pay for them even without a contract. Again, let's not go here. Let's be aggressive. Let's be good business people and insist on good, clean written contracts. Let's try not to change our position based on what's going on without a valid contract. Folks, this is another one of our several very important slides in Chapter 13. These in definitions, again, terminology is very important in a situation, a course like this where we're trying to cover a lot of ground and give you a lot of terminology. So when you're in a business meeting or you're working to obtain something for your family, that you have the terminology under control, you know the basics of the situation. So here we have a valid contract. Valid contract meets all of the standards from the slide we showed you a few minutes ago in terms of consideration, a legal purpose, willing parties. It's not a contract of adhesion. A void contract is one that doesn't meet all of these standards. Now, a very special circumstance is a voidable contract. And a voidable contract is one that has where one party can end the contract but not the other. And the example I use, and I don't know if there's a younger example of this, but most of you are aware of the performer, the alleged performer, Justin Bieber. And the story on him is as a kid, he's 14 or 15. He's up on YouTube. He gets famous on YouTube. Next thing you know, he's touring the country, but he's still under 18. So say Justin Bieber goes to your hotel and he's under 18 and he says, hey, my band and I, we need a bunch of hotel rooms. The hotel rents them. a bunch of rooms. He takes a bunch of room service and all that. And then the hotel tries to collect, and the Beeb says, hey, I'm under 18. I don't have the capacity to enter into this contract, and therefore I can get out of the deal. Well, the answer is since it's for food and shelter, is a little bit more complicated than that, is that the Beeb can void the contract, but he will still, under the theory we showed you a moment ago, quantum meruit, that he's responsible for the equitable value of what he received because it was for food and shelter, even though he's a minor. But in a different example, you may have a youngster who saved up his money and he wants to buy a used truck. So he and his buddy go to the used car lot. They pick out a used truck. They negotiate a price. He puts down $500. I'll be back tomorrow and get somebody to drive me over here tomorrow so I can drive the truck home, and I'll bring the rest of the money. So the young man goes to the used car lot the next day to pick up his truck, and the owner of the car lot says, tough luck, fella. Somebody came along and paid me more money last night, and I sold it to that person. Well, the interesting thing is that the minor can enforce that contract. It is the choice of the minor to enforce that contract, to say, hey, wait a minute, I had a deal. You didn't honor the deal. I can force you to deliver that truck to me for the price that we agreed on last night. Now, flip the whole scenario. The young man comes back the next day and says, I want my $500 deposit back. I've decided not to buy the truck. The used car lot cannot enforce it against the young man because he's under 18. So that's some examples of voidable contracts. And also the Justin Bieber example also gives you an additional example of the equitable remedy of quantum meruit. You may not get the whole contract value, but you get something that's you get something that at least gets you at least back heading in the right direction. Again, some important terms here. An executed contract has been fully performed. So one of my folk singers went out and was supposed to perform 2 sets at a coffee shop. She did that. Then she has fully performed the contract. It is executed. She's entitled to the full compensation under the contract. Executory contracts are yet to be performed. Now, this second term is an extremely important term in bankruptcy law. Sadly, in the United States, and COVID-19 could make it even worse, is a number of companies go bankrupt every year. A number of companies have filed for bankruptcy since the beginning of the COVID-19 crisis. And one of the advantages of going into bankruptcy is that companies can avoid contracts that are executory, that have not yet been performed. Here's an example. Say you're JCPenney and you've entered bankruptcy. You have 1,000 stores with leases. You know that about 200 of those stores are not paying the bills. So if you cancel those leases under normal terms, what will happen is that you will not be able to completely walk away. You're going to have to pay the landlord something to buy your way out of the lease. But if you're in bankruptcy, the bankruptcy court can just say, hey, you're excused from these leases, these executory contracts, and we're going to go ahead and take away those leases. You only keep the leases that you plan to perform. The other leases just went away in bankruptcy court. So it's a very tough deal for landlords in particular in these situations with these retail stores that go into bankruptcy. But again, this is the key term, executory, have not yet been performed. And of course, we have a breach of contract when one of the parties fails to perform as promised. And here are the remedies. So the first step is, obviously, we like money. So if you were supposed to be paid a certain amount of money for a contract and the other side didn't show up with the money, then that's usually a pretty good definition of what you need. Most contracts also call for, if you need to go to court to enforce the contract, to receive the funds that are involved. Now, the other side of that are equitable remedies, and we're going to talk a little bit more about this. But for instance, if you went to an antique auction and you saw a beautiful rare piece and you were the successful bidder, and you're going to come back and pick it up the next day, and you come back the next day and the auction house says, gee, you know what, we made a mistake. We sold that today to somebody else. And you said, well, wait a minute. I won the auction last night. It's my piece. I want it right now. And the auction house says, tough luck. Here's your money back. You don't have to take your money back. You may have the right of specific performance, which is an equitable remedy. And you may be able to say, auction house, you go find who bought it and you bring it back here, because that's a unique piece. It cannot be recreated. And I have a right to insist that it be given to me, since I bought and paid for it last night at the auction. Nominal damages. This is a case where you win, but you didn't really win. And oftentimes, this is by a jury that doesn't feel that the case is very serious. Probably the most significant nominal damage case in history goes back a few years to a competing football league. So there were a number of millionaires out there who were unable to get, it's very difficult to get a new football franchise. And so a bunch of rich people got together and they set up a 6 or 8 person football league, or teams, 8 teams, and said, well, we're all going to play with each other. There's lots of great players coming out of college who are not going to get on with one of the big pro teams, and we're going to capitalize on that market. Well, the league failed miserably. Millions and millions of dollars were lost. And so they went to court and they sued everybody. They sued the NFL. They went after a bunch of other people, and they said, the television stations and things like that. And they said, you all are ripping us off. You didn't honor your what you were supposed to do. And you deliberately blocked us and prevented us from being successful. So in that case, to my surprise, the jury awarded $1. And the best we can tell in that case, the jury felt that because this group of millionaires was so disorganized and the idea of the league was so poorly constructed, that they were never going to be successful. They were never going to provide the quality of football that would justify a television contract, and therefore it was a bogus case. So it's a very great example, well-documented example of a nominal award. So it's something to keep in mind there. Now, we've already talked about in the torts chapter, and actually at the beginning of tonight's discussion, about compensatory damages. And so again, these are the types of things that get the person back to where they started from. Lost wages, medical costs, things that are quite specific and can be documented. Attorney's fees are not included in most cases, however, in contracts. Many contracts do provide for an award of attorney's fees. And now one of the pieces, and this may tie in again with the question about eviction that we had earlier this evening, and that is compensatory damages and the special aspects. So suppose that the tenant runs out of money and moves out, and there's still a year left on the lease. The landlord can say, well, gee, I'm in the great position here because I'm going to sue the party that moved out early, and I'm going to get a year's rent from that party. Not so fast. The law says that the landlord has a responsibility to mitigate the damages. In other words, you've got to put an ad in the paper or put a poster up or a big sign out front and say, hey, we've got space for rent, and you have to aggressively promote that space. You can't just sit there and wait to collect your rent from the courts. So that's the duty to mitigate damages. Now, One of the most controversial areas of contract law are consequential damages. Part of this is because of the little bit of the difficulty of proving what you've lost due to the deal. So you might say the party was going to buy 100 widgets from us, and we spent $1,000 getting ready to make those 100 widgets. But the purpose of doing that was the fact that we were going to make $500 a profit. Well, the compensatory damages are going to be the $1,000 you spent to prepare to make the 100 widgets. The consequential damages are the $500 that you would have made as a result of the profit that you expected to make. That's consequential damages. Now, many well-written contracts between businesses provide that there will be no consequential damages paid. And so whether the contract's breached or not, you can only get what you've invested in the deal. Now, as an attorney reviewing contracts for businesses, a lot of times I'll encourage businesses to not agree to the waiver of consequential damages or to agree to some specific formula to calculate damages, but to not just completely walk away and say, we're not going to give you any consequential damages. So I think it's something that's worth looking at. Folks, this is an interesting case, is the Lewis case. And one of the things that's brought up in this slide is as a performance bond. A performance bond is actually a form of insurance. And it's in a number of public contracts, public construction contracts, to, like in this case, to build a new school or build an improvement to a school. If you were going to build an addition to a post office, a federal government contract, a lot of construction contracts with a government entity require a performance bond. And the way that works is if the construction company does not timely complete the construction project, the public entity, the school district or the post office, can go to the performance bond company and say, hey, I don't care what it costs, but you need to finish that construction for me because the guy that you insured didn't do it, or the gal that you insured. So this is a pretty interesting area of the law. And I want to make sure that you're aware of this concept of performance bonds. And one of the issues that does come up is a number of small minority businesses are not able to get performance bonds and therefore have difficulty bidding on federal contracts. The Small Business Administration, the SBA, a federal agency, actually tries to help certain businesses with performance bonds because they may have trouble getting them on their own. So there's some things in there. Also note the difference between general and special damages. This is kind of a parallel situation to what we just talked about on the prior slides, and that is that the general damages are the cost of doing the job. The special damages may be for the delay in not being the job being finished on schedule. Now, again, we mentioned punitive damages when we talked about torts earlier in the basic law module. And again, it's easy to think about it because punitive looks a lot more like our current day word punish. And these, again, are layered on. And an alternative word for punitive damages is exemplary damages. Again, a logical way of thinking through that is we want to make an example out of this company say the company hires a truck driver with a horrible record, and the truck driver wrecks your car and hurts you, and you lose work, and you have medical bills, and you go through a lot of pain and suffering, and you say, you know, it's just not enough to get my medical bills back and my lost wages. These guys really did me wrong. I've had a lot of pain. And but more important than that, they just should be more careful. If somebody's going to operate these big 18-wheeler trucks, they should be responsible for that. They should make sure that they hire drivers who have great safe driving records. And so to make sure that other trucking companies are conscious of the fact that they need to hire good drivers, we're going to make an example out of this trucking company, and we're going to ask for millions of dollars of damages to encourage them to be more careful. So that's something to think about. Now, because it's sometimes difficult to come up with the right number of damages, a number of contracts have something called liquidated damages. And in fact, there's a special type of contract that often has liquidated damages. And that's something that some of you may be asked to sign or may have already signed. And that is a non-compete agreement. So you go to work for a company, and the company says, you're going to have access to a lot of information on our clients and our products, and we don't want you to run down the street, set up your own business, and compete with us. So they say, so here's your employment contract. But by the way, if you breach your employment contract, we're going to seek liquidated damages from you, and at least 2 months of your wages you will owe us if we sue you in court and are successful that you violated your non-compete agreement. So that 2 months of wages, or however it's written, that is a liquidated damages clause. So the H&R Block case, interesting case. In order to go to work for H&R Block, they do provide a lot of training so people know how to run an H&R Block office or how to do taxes if they're just a preparer for H&R Block. And so the idea is not to train these people up how to do all this stuff and then have them go down the street and set up their own firm doing tax preparation. So the idea was to prevent them from getting the clients that were developed while they were being paid by H&R Block, prevent them from running down the street taking the clients with them. So this is where we get into the issue of reasonableness and also the level of liquidated damages. And one of the things to keep in mind is you say, well, gee, we've got this great contract. It says we're going to get 2 months of wages as liquidated damages and all that. Keep in mind that courts, judges have their own minds. And so they might find that the liquidated damages are excessive or unreasonable and may not award those damages. Now, I've mentioned the term equitable remedies several times tonight, and we've already mentioned all of the terms, but this slide helps to bring them together in one place. So these are the best known equitable remedies: specific performance. And I used the example a few minutes ago of a rare antique. One of the other best known areas of specific performance is real estate. A contract to buy real estate. The idea being that every piece of real estate in the world is unique. No two pieces of real estate are exactly the same. And therefore, if you have a contract to buy a particular piece of real estate, say you're in one of these mass production neighborhoods and every house looks just like the house next to it, and you were supposed to get this house A on this block, and the builder comes back to you and says, hey, you know what? We sold that house to somebody else. We're going to give you the identical house 1 block over. And you say, no, 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 no. I had a firm contract. I had my mortgage approved. You had my security deposit. That specific house is my house. And I'm going to go to court and enforce specific performance if you do not honor the deal. So that's specific performance. So again, real estate, antiques, other things that are rare and cannot easily be replaced. We talked about rescission. That's putting the parties back where they started. You don't get any profits or anything like that. But if there's some money that have been spent by the sides, then that money may go back to them. And then restitution is if somebody has put up some money to get a project started and then the other side backs out, to at least get them back to where they're not out any money. And again, these subsequent slides, one each for specific performance, rescission, and restitution, give you a little additional information.